Hello, these are my thoughts on the bill currently going through the House of Lords that may impact upon people who wild camp in any vehicle on private or common land. Kill the Bill protests continue to be held across the country, but it's important to realise that the bill deals with many different things, for example, assaulting emergency workers and placing some limitations on our ability to protest. This video is only going to be concerned with part 4 of the bill, which deals with unauthorised encampments. I'll place a link in the details so that you can read the bill for yourself and make up your own mind. I'm not a lawyer, and none of what I say should be taken as legal advice. As the bill progresses, it's likely to change, and if you're unhappy with anything, then write to your MP and let them know. I assume people are asking for my view on the bill because of my police experience, and I think I do understand how the police are likely to make use of any new powers. I am not speaking on behalf of any police force. These are just my personal opinions. First of all, it's important to point out that ever since 1994, the police have had powers to remove trespassers on private land. Part 5 of the Criminal Justice and Public Order Act 1994 already gives police powers to remove trespassers on private land. Of course, before they can do this, certain elements have to be met before you can be told to leave by the police. As the law stands today, there has to be 2 or more people trespassing. They have to have an intention to reside there for any period. The police also have to be satisfied that the landowner has taken reasonable steps to ask them to leave. But this alone is not enough. The police also need to have evidence that any of those trespassers have caused damage or used threatening behaviour, and the trespassers must have 6 or more vehicles between them on the land. If these conditions are met, then the police can already tell them to leave, and if they refuse, their vehicles can be seized and the trespassers can be prosecuted. The new bill is called the Police, Crime, Sentencing and Courts Bill, and it's seeking to make changes to this existing legislation. If it passes into law as written, the elements of the offence will change quite significantly in the favour of the landowner and the police. First, only one person over the age of 18 needs to be trespassing. They need to be residing on the land without the consent of the occupier. Only one vehicle needs to be present. The occupier, their representative, or a constable must have requested them to leave the land and remove anything under their possession or control. In order for the offence to be complete and a conviction to be secured, the police would also have to prove beyond reasonable doubt that one or more conditions had also been met. These conditions are: significant damage or disruption has been caused or is likely to be caused as a result of them residing on the land. There is also a preemptive condition, and if they are not yet residing on the land, then significant damage or disruption is likely to occur by them residing on the land. The third condition is that significant damage or disruption has been caused or is likely to be caused because of their conduct whilst on the land. The last condition is that significant distress has been caused or is likely to be caused as a result of offensive or disorderly conduct. One or more of these conditions is all that's required to make the offence complete. If someone lawfully required to leave fails to do so as soon as reasonably practicable, or having left returns within 12 months, they commit an offence. On summary conviction, you can receive a custodial sentence not exceeding 3 months and or a level 4 fine. It is a defence to show that the accused had a reasonable excuse for not complying with the order to leave or for entering the land after being asked to leave. Okay, we have some key points to understand. Damage includes damage to the land, damage to property on the land, damage to the environment, including excessive noise, smells, litter, or deposits of waste. Disruption includes interference with a person's ability to access services, facilities, or to use the land, access to water, fuel, or energy. Under the legislation, occupier includes the owner or person entitled to possession of the land. Offensive conduct includes the use of threatening, abusive, or insulting words, signs, or behaviour. Vehicle includes any vehicle, caravan, whether suitable for use on the road or not. Residing means residing for any period, even if you're just proposing to stay overnight, and even if the person staying has a home elsewhere. So let's consider some scenarios, and I emphasise this is just my personal opinion, not legal advice. Okay, scenario number 1. A young couple with a camper van park in a private lay-by for the night. They do not deposit any waste, litter, or cause any damage. Later that night, the landowner asks them to leave the land, and the couple remain calm and very politely explain that they have been travelling all day and are very tired. They ask for permission to stay and rest, and state that they intend to leave very early the next morning. The landowner calls the police, and when they arrive, the couple remain calm and politely explain to the officers that they need to rest and will be leaving very early next morning. In my opinion, no offence is committed under the new Act because not all of the required conditions are met. The police should explain this to the landowner and it reverts to being a civil matter. Now personally, I would always move on if asked, as there are plenty of places I can tuck our little van. I would only not move on if I had a reasonable excuse not to do so. I would be very wary of telling a police officer that you've had too much to drink in order to be able to drive. Okay, let's consider a different scenario. A family use their powerful van to pull down a fence or gate in order to gain access to private land, and the landowner discovers them and asks them to leave. They refuse and the police are called. A witness saw the damage being done, and the police now have all they need in order to order them to leave the land. They can also arrest them for criminal damage, and their vehicle could be seized under the new legislation. Okay, one last scenario. 3 vans pull onto private land for a bit of a party. They damage trees, cutting wood for fires, and react aggressively towards local residents and the landowner when told to move. It's clear that they're dropping rubbish and using the land to dispose of chemical toilet waste. All the elements for an offence are present, and if they refuse to leave, vehicles could be seized. So how will the police likely react to these new powers? In my experience, that mainly depends upon the reaction of the person suspected of committing the offence. Generally, police intervention starts off with gentle words of advice. If the person remains calm and civil, then it's possible to negotiate a good outcome for all concerned. I would always ask if it's possible to just stay the night and leave as soon as I feel able to drive. If, however, the person becomes aggressive, then the officer will be mentally ticking off the required elements of the offence and will pounce as soon as they are all met. This is an individual choice. So, as far as the wild camping we do, I'm not that concerned. We don't cause damage, drop litter, or empty the toilet. We tend to arrive late and leave very early and only stay one night. Sometimes we leave the place better than we found it. To be honest, I have no idea what will eventually happen, but common sense tells us all that anyone who commits an offence under this or the existing Act is no real friend of the wild camping community. In truth, they give us a bad name and ruin it for all the decent people who love to wild camp. Okay, I do have some concerns. The first one relates to the police being able to ban you from returning to the land for 12 months. My concern is what will be the definition of land. Does it relate to a specific lay-by, or does it relate to all the land owned by the occupier? For instance, here in Sussex, the National Trust own large tracts of land. So would a notice for one of their car parks apply to all of their National Trust property? The next question I have is, who needs to cause the damage or disruption? Clearly, if you're with other people and they are causing damage or disruption, you probably would be captured by that. But does the damage or disruption have to be caused by you? From my reading of the bill, I think that is the case. If, however, the damage or disruption can be caused by anybody, in particular people who have been there before you, then again, I think this is a very disproportionate solution, as any previous damage could be grounds for banning you from staying overnight. My last concern relates to the preemptive power. So even if you haven't decided yet to stay there, does this legislation allow the police to assume you're going to stay and thus tell you to leave the land straight away? Because what effect would that have on our ability to go out for the day and just enjoy a place and then leave when it gets dark? I'm going to write to my MP asking these questions, and if you can think of any more, I urge you to do the same with your MP. I know lots of people believe that this will make no difference at all, but I don't hold that view. MPs want an easy life just like everybody else. So give them some work, ask them these questions. Let's follow the course of this bill and make sure that it doesn't ruin it for everybody. So that's my current views on the bill currently going through Parliament. If you found it useful, please give us a like and consider subscribing.